Alex here with a high conflict child custody video on requirement to attempt resolution. This is, I guess I'm going to call it a niche video, but it is a big red flag for people to look out for in their local court rules, because it was brought to my attention that it is one of the local rules in Clark County, which is the 8th Judicial District Court of Nevada. It's only, as far as I know, it is only um, in Clark County. None of the other judicial districts or counties have copied this rule. If anyone wants to take a look, it's EDCR 5.501. It's a rule that just applies to this county, and it would have kind of caught me off guard because I am from the 2nd Judicial District Court. That's where I did all of my litigation, and so there was nothing like this in my district court rules, and I'm pretty surprised by it. I think it's a good rule now that I've read it, but I just think it. Okay, I don't just think, I know. From what I've heard, this rule catches a lot of non-attorney litigants off guard. This rule, from what I've read also in a couple of cases, has caused some non-attorneys to get hit with attorney fee sanctions, which is sad because most people, once they read the rule and know about it, understand it and agree with it. But if you don't know, if you haven't read it, it can blindside you. So what it is, it's a local rule that requires you to try to work something out before you file a motion. So basically, when you're about to file a motion in the 8th Judicial District Court, you need to identify the issues that you're raising in the motion and send your opponent an email or an Our Family Wizard or something, letting them know that these are the issues that you're about to bring to the court's attention, and that you're giving them a chance to work them out. Some attorneys, because attorneys have to comply with the rule too, actually put the rule in the letter that they send. So I've seen some examples of attorneys sending like an email or a letter to their opponent saying, I want to work these things out, and then at the bottom they'll say something like, this communication is pursuant to EDCR 5.501. It sucks to have to bring this up, and it sucks that it's a niche kind of issue, because I really have no clue if this is going to apply to any of my other viewers, but at least people here who are representing themselves can look into their local court rules and try to find out if there's anything similar, because if there is, and you don't know, and you file a motion without trying to work it out, you're going to get hit with an award of attorney fees. Specific to that rule that I just mentioned, EDCR 5.501, there is a provision that says that if you do not comply with that rule, you will have to you will be sanctioned and you will have to pay attorney fees. I've talked about defending against attorney fees in a video. It's actually called Defend Against Attorney Fees, and it is crucial for anyone who is representing themselves to defend against attorney fees wherever possible, because that financial impact of attorney fee sanctions on you will cripple your ability to go toe-to-toe with your opponent's attorney. One attorney fee award could go upwards of $3,000 or $4,000. You already are too poor to pay an attorney to even represent you. And so the slap in the face of you having to pay your opponent's attorney fees when you can't even afford one yourself is beyond infuriating. I talk about it in that video, Defend Against Attorney Fees, and now having seen this rule coming to my attention, it kind of alarms me. I agree with the rule. The problem is that some parents don't know that it's there, and so they're getting blindsided, and I don't think that's fair. But ignorance of the law is no defense. It really isn't. Not in civil law, not in criminal law. So unfortunately, or fortunately, because it is a good rule, it would be nice for it to be more well known, of course. There is a local rule in the 8th Judicial District Court. Look out for something like that in your state, just in case you have to do, just now that I think about it, looking back, I never really kind of just filed a motion out of the blue with my ex anyway. I, of my own desire, and having been attacked numerous times as a vexatious litigant or a harassing filer, I feel like I've never actually just filed something without having asked my ex. But it may have happened, especially during that first year or two, because I was trying to figure this all out in the beginning, and I was trying to grow. I was trying to emotionally mature and develop my own, sort of view of the court system at that time. So it's possible that during that first year or two, I did do that. But I know that towards the final years, I was pretty on top of making sure that I did reach out to my ex, even though I knew she wouldn't reply, even though I knew she wouldn't care. I at least knew that I needed to get the documentation and communication in writing so that I could fall back on that later on when I would invariably be called a vexatious litigant or a harasser. So anyway, I think with that, I've made my point on this video. I'm curious to see if anyone here has seen that there is a similar local rule, or maybe even a statewide rule in your state or locality that actually does sound just like EDCR 5.501. And if so, go ahead and mention it in the comments below, because it would be nice for other viewers to see that this is actually something that's all over the place. So with that, I'm going to go ahead and end this video, and I'll see you guys next time.